In Chapter 24, we're going to look at real property and environmental law. Real property is immovable and includes things like land, buildings, homes, airspace, subsurface rights, plant life, vegetation, and fixtures, which is personal property that becomes permanently affixed to the real property. Intent is the key. This is determined by the fact that the property can't be removed without causing damage to the realty, and that it's adapted in such a way that it becomes part of the real property. Fee simple or fee simple absolute is the greatest aggregation or bundle of rights to property that you can have, and it can be assigned to your heirs. It's subject to applicable zoning, noise, and environmental laws. A life estate is short of fee simple absolute. It's an estate that lasts for a life of a specific person. For example, A to B for B's life gives B a life estate, and that grant to B is called a conveyance. When B dies, the property returns to A. If the grant was A to B for the life of B, then to A, or A's heirs or assigns, in the same condition, minus normal wear and tear. That granting of a life estate creates a future interest. If it goes back to A, it's called a reversion, and if it goes on to someone else, say for example C, then that is a remainder. During B's life, they can possess, use, and take fruits of the property, but they can't take it for themselves. They can't destroy the property. They're basically holding on to it for that future interest. So far we've talked about possessory interest. Non-possessory interest includes easements and profits. An easement is a right to make limited use of someone else's real property without taking something from it. A profit would be that right with taking some product from the land. These are either appurtenant or engross. Appurtenant means it's adjacent, and gross means it's physically separated. In other words, like for example, a utility company is not located right beside your land. That would be an easement in gross. An easement appurtenant might be you have a right to travel across someone else's land to get to the road. Easements can be created in a deed or will, by implication or implied, by necessity. That example of a property that's landlocked and you need to get to the main road, so it's created by necessity, or adverse possession. Somebody continuously uses it. This might be like a path or beach. Easements can be terminated by deeding the property back to the original owner of the land, or abandoning it, as an example. License is a non-possessory interest. Basically, it's a revocable right. It's not permanent like an easement or profit. It comes with the ability to revoke at any time, but without the ability to take things unless that happens to be part of the agreement. It's personal. That means it goes with a person and it doesn't continue with the land. Real property can be transferred by conveyance, for example, a real estate sales contract. Other means include gift, will, inheritance, sale, which we'll talk more detail about. Inheritance again, adverse possession, and eminent domain. Real estate contract would be similar to a sale of goods. Instead of personal property, it's real because it includes a transfer of ownership with warranties. It usually includes the purchase price, the type of deed that's required, condition of the premises, and whether the fixtures are included or not. It's usually contingent upon financing, and there's usually an implied warranty in the sale of new homes that the property is habitable, able to be lived in. The seller warrants the house is in a reasonable working order and has reasonably sound construction. The seller has a duty to disclose of hidden defects, defects that materially alter the value of the property and the buyer could not have reasonably discovered. A deed is an instrument that conveys an interest in real property. It has to have the name of the grantor and grantee, words evidencing an intent to convey, which could be simply from A to B, a legally sufficient description of the land, the grantor's signature, the one making the grant, and actual delivery of the deed. There are different types of deeds. A warranty deed is warrants title to the property. A special warranty deed only warrants the title of the grantor, not previous owners. You want a warranty deed over a special warranty deed. We mentioned implied warranties in new homes. A quitclaim deed only conveys whatever interest somebody has in a property, which may be nothing. In other words, a quitclaim deed is a deed without any warranties. Or you can get it through some kind of sale. If you do like a tax sale, sheriff's sale, one thing you need to be concerned about is period of redemption, where the person who lost the property could pay what's owed and get the property back. If an owner of real property dies, their property could be transferred by a will, which is testate, or without a will, which is intestate, and then the laws of the state would control how that real property passes. Adverse possession is statutory. If somebody possesses someone else's land for a sufficient period of time, actually and exclusively, open, visible and notorious, continuously, peaceably, but hostile and adverse to someone else's interest, they can actually get title to the property just as if there had been a conveyance. And then eminent domain would be that Fifth Amendment right of the government to take property for public purpose as long as they give just compensation. We can also talk about landlord-tenant law. It's created when a real property owner or lessor or landlord agrees to convey the right to possess the property to a lessee or tenant for a certain period of time. A tenant has exclusive possession except against the landlord. The landlord has some restrictions during the term of the tenancy. It's covered by a variety of laws, common law, state and local statutes, and even some states have tried to create uniform laws. Different types of tenancies. A tenancy for years is created by an express contract, and the property is leased for a specified period of time. Periodic tenancy doesn't specify how long the lease lasts, but rent is paid at periods or intervals. A tenancy at will, even without an express term, somebody occupies the land and they're permitted to occupy it, tenancy at will can be created. If they have no rights and they're not wanted there, then that's wrongful possession. A lease agreement can be oral or written. An oral agreement may not be enforceable under the statute of frauds and other laws. It gives the tenant a temporary right to exclusively possess the property and to enjoy the property. It governs the use and maintenance of the premises, not only what the tenant's responsibility is, but also the landlord's responsibility for common areas, and usually dictates rent and the fact that it could be withheld, but if it is, it's usually put in escrow pending repairs. One issue that comes up is transferring rights to leased property. If the property is leased and there's an assignment, the lessee typically can transfer their lease to an assignee if the lease permits it. However, the assignor is still liable for the rent. In a sublease, the tenant transfers all or part of the premises for less than the entire duration of the lease. Three areas of environmental law in terms of sources are common law, state and local regulation, and federal regulation. We'll look at each one of those. Under common law actions, the big ones are nuisance and negligence and strict liability claims. In nuisance, a person who's harmed claims their property is unreasonably interfered with their right to use or enjoy that property. A business or person could allege a failure to use reasonable care towards a party whose injury was foreseeable. So this is a theory that a tort theory, a strict liability. As we talked about before, there might be some kind of statute that prohibits certain action related to real property. Federal regulation, federal environmental policy is achieved through federal agencies. For example, the APA, they're the regulatory agency that takes environmental factors into consideration when making decisions. Also, National Environmental Policy Act, it doesn't directly deal with pollution control, but it does require an environmental impact statement when major federal action relating to the environment is undertaken. The EIS must analyze the impact of the action on the environment, any adverse effects and alternatives, as well as irreversible effects that the action might generate. Clean Air Act provides the basis for issuing regulations to control pollution coming from both stationary and mobile sources like factories and cars, and it prescribes the use of pollution control equipment that represents MACT, or the Maximum Achievable Control Technology. Here are the goals of the Clean Water Act. Basically, it relates to anything that's navigable, including wetlands, and also safe water and drinking water, or swimming and drinking water. There's also other federal laws in the area of water pollution. Toxic chemicals, here are some big ones. In terms of pesticide and herbicides, there's FIFRA and the Toxic Substance Control Act, regulating everything from what types of pesticides are used around food. The Toxic Substance Control Act requires anyone planning to use chemicals first determine their effect on human health and the environment, and also has restrictions on labeling, or requirements on labeling, restrictions on use of substances. In terms of hazardous waste disposal, there's Resource Conservation and Recovery Act, authorizes the EPA to issue regulations for the monitoring, transporting, storage, treatment, and disposal of hazardous substances in CERCLA, or the Superfund, and this is designed to ensure the cleanup of hazardous waste sites and to assign liability for the cost of the cleanup. Somebody who puts hazardous waste on a site, who occupies it with hazardous waste, or even transport it, it could be responsible. They're known as potentially responsible parties, and they can have joint and several liability. In other words, you could go after one, some, or all of them.